Mic check 1 2 1 2 3 4. Mic check 1 2 3 4. All right, thanks. Yep.
Yeah, same guy. That was fine.
You good on that?
Yeah. Yeah. Oh, maybe. Actually, just to test it, you mean? Yeah. There's speakers right up. And I guarantee for a 10-minute or 2 hours driving like that. Okay, honestly, I wouldn't have to see it. I would have been fast. Yeah. This deserves a read. What's that? What is your mic? Should I dismiss your case? Dismiss it. But I was talking to Jim about I had somebody sitting. Thank you. Hello. Bruce, hello. Hey, morning. Hey, Bruce. How you doing, Jack?
Are these mics hot, gentlemen? Ladies? They're hot. Okay, thank you. Thank you very much for letting me know. Yeah, survivalist. Yeah.
Feel free to contact me. Okay. Call me.
All cell phones have to be turned off.
Just pretty brief though, Bruce. Bruce, pretty brief report.
All right, so there is no question on the session. I will Judge Patrick Carroll preside.
Good morning, everybody. Please be seated.
All right.
Yeah, got it.
J.D. Tomlinson, 2024 CRA 02634, charged by the state of Ohio, tampering with evidence, intimidation, attempt bribery.
Good morning, sir.
Good morning, Your Honor.
Please be seated.
Oh,
I
thank
appreciate
you.
the courtesy.
Thank you.
But remain seated. First of all, before we begin, I see there's a lot of people here in the courtroom. This is a court proceeding. I understand that some of you may have some deep feelings about this case, one way or the other. I do want to remind everybody that this is a court proceeding, and it must be respectful for everybody who's here in the courtroom. Any comments, disturbances from the audience will not be tolerated. Anybody who creates any disturbance will be escorted out of the courtroom. These are matters that are of concern to everybody involved, and we have the orders that we all must follow and procedures that we all must follow. Mr. Tomlinson, you are, I do know for the record, and I want to say this, I understand that both Mr. Tomlinson and Mr. Burge are attorneys licensed to practice in the state of Ohio. Nonetheless, I am required to go over certain legal procedures, and I I know, I would assume that you're aware of those, and any questions I ask you, please, they're not to be meant in an insulting way in any manner. It's just, I've got to follow the rules just like everybody else.
We understand.
So, with respect to Mr. Tomlinson, at this point, are you represented by an attorney?
Judge, no, we are not. We have been in consultation at this moment. No.
Excuse me, I just want you to address yourself to you. I'll address.
Oh, I'm
Mr.
sorry.
Burge.
I'm sorry. I am not, Your Honor.
All right. And are you intending to get counsel in this?
Yes,
matter?
sir.
All right. And at this point, I can proceed with the arraignment if you would rather, or the initial appearance, excuse me, if you would rather have me go through the reading of the complaint and charges at this time, or wait until you've had an opportunity to consult with counsel.
I would wait, Your Honor.
And you have been served with the complaints, is that
I
correct?
have.
And I do want to advise you, again, that you have the right to remain silent, and any statements you make other than to your attorney can be used against you. Do you have any questions at this time?
No, Your Honor.
Right. With respect to Mr. Tomlinson, the court will order a fingerprint order, so we'll have you, you'll need to do that, and that's pursuant to state law. And anything else, Mr. O'Brien, at this time?
No, Your Honor. Ron O'Brien here today on behalf of the state by virtue of an appointment by the Elyria Law Director due to an apparent or potential conflict, and I would not have anything further at this time. I would be asking the court for a recognizance bond on both defendants as well as stay away orders with respect to one of the alleged victims. And for purposes of the record, I have applied to Marcy's law with respect to the hearing. At least I believe Mr. Liu has a representative here. But Mr. Liu he had a prior court hearing, so he is present here in court. And Ms. Battistelli, the other victim, did not wish to be present.
Are you asking for a no contact order with respect to Mr. Liu, or just the other alleged victim?
Not with respect to Mr. Liu, just with respect to Jennifer Battistelli.
And Mr. Liu, for the record, that's correct?
That's correct, Your Honor.
Any objection to that?
No, Your Honor.
No, Your Honor.
Thank you. And Mr. Burge, going over the same procedures, first of all, you're aware of the charges?
Yes, sir.
And you've been served with the complaint?
Yes, sir.
All right. And I want to advise you that you have the right to remain silent, and any statements you make about the matter can be used against you other than to your attorney. Do you understand that?
I do.
And you are not represented by an attorney at this time?
That's correct, Your
And
Honor.
are you intending to get an attorney?
Yes, sir.
And have you contacted an attorney or had an opportunity to discuss this with an attorney?
I've contacted attorneys, Your Honor, but I haven't discussed this case with them.
Okay, you've not yet retained counsel?
No, sir.
And I understand that this was late Monday or late Tuesday afternoon.
Yes.
Without getting into names, do you have an idea who you're going to retain?
Not.
Yes or no is all I needed.
No, Your Honor, I don't.
All right. And again, is Mr. Tomlinson same with you?
No, not exactly, Your Honor.
All right. And I know we officially didn't call the case. Do you need a Mr. Burge?
James Burge, 2024 CRA 02633, charged by the state of Ohio, tampering with evidence, intimidation.
Thank you. So let me ask you this, how much time, and I know these are separate cases and separate charges, but kind of addressing the two of you together, how much time do you think is necessary to obtain counsel?
Could we have 2 weeks, Your Honor?
I have no objection to that. Any objection, Mr. O'Brien?
No, Your Honor, I had a discussion with both Mr. Burge and Mr. Tomlinson. They indicated they did not have counsel and that they did desire to have a preliminary hearing, however, and would request several weeks, and we have no objection to that.
Okay, and you can remain seated. I appreciate the courtesy, but you're asking for 2 weeks, is that
Yes.
for the, let me finish, 2 weeks for the initial appearance? Or are you asking for or requesting a preliminary hearing at this time? Or do you want to talk to counsel before you make that decision?
I'd like to talk with counsel.
Could we, Your Honor?
Yes, I'm just trying to clarify.
Sure.
If the 2 weeks is, the next thing we're going to schedule is a continuation of this proceeding or go to the preliminary hearing. And you're just asking this proceeding today to be continued.
Yes, Your Honor.
Yes.
All right. And Mr. Burge, do you have any objection to the no contact order as well?
No, Your Honor.
All right. So we're gonna, we'll have you sign those documents. We will get a date and proceed from there. Do we know if we have a date yet?
We have a couple dates, November 6th, November 7th. October 16th.
October 16th, would that give you enough time?
I think it would, Your Honor.
Let me, October 16th in the afternoon?
That would be fine.
That's fine, Your Honor.
Do we have a specific time yet, or we'll get one?
2 o'clock.
How about 2 o'clock? Any-
That works, Your Honor.
All right.
And that would be for the initial appearance.
Exactly, right. That'll be for the initial appearance, and then depending on what happens there, we will schedule it for a preliminary hearing, if applicable.
Okay, thank you. Your
All
Honor.
right? Right? Yes. I thought he had it. And again, for the record, I'll read this into the record and have you sign it, that for both of you, you are to have no contact with the alleged victim, Jennifer Pazzelli, either personal or with her residence. No contact means the defendant cannot write, call, or text the alleged victim. If the defendant goes somewhere and the alleged victim is there, the defendant is required to leave. If the defendant is somewhere, even if the defendant arrives first and the alleged victim shows up, the defendant should leave. The defendant may not have a third party contact the alleged victim on behalf of the defendant. If the alleged victim contacts the defendant cannot respond to any contact by the alleged victim. A response to any contact initiated by the alleged victim will be a violation of this order, and the same as if the defendant initiated the contact. The defendant may not go to any social media or post any comments to or for or about the alleged victim. Failure to comply with this order could result in bond being revoked and defendant being arrested. I trust that that won't happen here, but just wanted to read it for the record as well. And Mr. O'Brien, I would ask you to, you will notify, well, the one alleged victim is here, and you'll notify the other one.
Yes, Your Honor.
All right, and I want to say this on the record. I realize that let me take a moment to think about this. I realize that this is an unusual situation in that Mr. Tomlinson is an elected official, and as I understand, up for election this year.
I am, Your Honor.
And the reason I point that out, this has nothing to do with politics here. Politics does not belong within these four walls. However, I don't want to get into a situation where the alleged victim shows up at any public appearance that Mr. Tomlinson would be required to appear, whether it's a fundraiser for him, some speaking forum, or anything else, that she would show up. I understand Mr. Lude knows this as an attorney, but I mean, technically, under this court order, he would be obliged to leave. And that certainly isn't the intent of the order. So I would ask you, in talking to her, to make sure that she is fully understanding of this. And any issues that should arise by her conduct could result in the dissolution of this order. Everybody understand?
Yes, sir.
I would specifically advise her of the court's comments, Your Honor, and I don't think she has any intention of having contact.
I understand, but I could envision something happening in a week or two, and should that arise, then the no contact order can be dissolved or terminated. If it's going to turn into, it's meant to be a shield, not a sword. Anything else at this time?
No, Your Honor, thank you.
No, Your Honor.
We are going to have the and I probably should have said this in the beginning. But for the record, my name is Judge Patrick Carroll, and I have the authority on this case as a visiting judge by order of Chief Justice Kennedy of the Supreme Court of Ohio. The order of assignment on file both with this court and the Supreme Court of Ohio. So we will have 2 copies of the fingerprint order. You'll have 7 days to comply with it. 1 copy for the clerk, 1 copy for each one of you. In the event that you secure counsel sooner than anticipated, to have the respective counsel file a notice of appearance and contact Mr. O'Brien.
Yes, sir.
And your contact information is available.
Yes, Your Honor.
We'll have the no contact order for you. Gentlemen, would you approach? We can give you this is the no contact order. Yes. Take a moment to review that. Any questions, please feel free to. And then for the record, this continuance is being requested by the defense, is that correct?
Yes.
Yes,
So
sir.
that would extend any time, but for the record, is there a time waiver at this time as well?
Yes.
Yes, Your Honor.
So you're waiving it, because I'm required to set this case to trial or for a hearing within 15 days from the date of service, which would have been last Tuesday.
We'll waive that time.
We'll
All
wait
right.
that.
At least for the purposes of the proceedings in this court.
Thank you.
Yes.
All right. Anything else at this time?
No, sir.
No,
All
sir.
right. We're adjourned at this time. Thank you
Thank
all.
you.
Thank you, Your Honor.
Yeah.
And then if you wait, we'll give you a copy of the orders.
Thank you, Your Honor.
All rise.